The Hindu Marriage Act 1955, Section 2, Application of Act. Clause A of subsection 1 of section 2 says that this act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashaiva, a Lingayat, or a follower of the Brahmo Samaj, Prarthana Samaj, or Arya Samaj. Any forms or developments means, for example, in the month of January, in different parts of India, celebration of the festival of harvest is done with the different names as per the custom and tradition in that particular region. In Karnataka, it's called Makara Sankramana. In Andhra Pradesh and Telangana, it's called Makara Sankranti. In Tamil Nadu, it's called Pongal. In Kerala, it's called Makara Vilakku. In Jammu and Kashmir, it's called Shishur Sankrant. In northeastern states, it's called Magh Bihu. In Punjab, Haryana, Himachal Pradesh, it's called Lori. In Uttar Pradesh, it's called Kicheri. In Gujarat, it's called Uttarayan. Clause B of subsection 1 of section 2 says that this act applies to any person who is a Buddhist, Jain, or Sikh by religion. Clause C of subsection 1 of section 2 says that to any other person domiciled in the territories to which this act extends, who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein if this act had not been passed. Explanation of section 2 subsection 1 clause C. To any other person or individual domiciled in the territories to which this act extends, who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that a person or individual is not governed by Hindu law, that a person or individual is governed by usage and custom of that particular personal law in respect of the matter or topics discussed in Hindu law, for example, topics like marriage, divorce, etc. Or, in simple terms, it is to be presumed until the contrary is proved that any person or individual who is not a Muslim, Christian, Parsi, or Jew by religion is governed by this act. Who is eligible as Hindu? The following persons are Hindus, Buddhists, Jains, or Sikhs by religion as the case may be. Any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jains, or Sikhs by religion. Any child, legitimate or illegitimate, one of whose parents is a Hindu, Buddhist, Jain, or Sikh by religion and who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belonged. Any person who is a convert or reconvert to the Hindu, Buddhist, Jain, or Sikh religion. Subsection 2 of section 2, notwithstanding anything contained in subsection 1, nothing contained in this act shall apply to the members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution unless the central government by notification in the official gazette otherwise directs. Explanation of subsection 2 of section 2. Article 366, Clause 25 of the Indian Constitution defines term scheduled tribes and Article 342 tells the way these tribes may be notified. This was done by the Constitution Scheduled Tribes Order 1950 and by the Constitution Scheduled Tribes Union Territories Order 1951. This subsection says that persons belonging to such notified tribes in matters of marriage continue to be governed by the personal law which was applied to them hitherto or until now and not by any of the provisions of this act unless the central government by notification directs that any such provisions should be applicable to them. Subsection 3 of section 2 says the expression Hindu in any portion of this act shall be construed as if it included a person who, though not a Hindu by religion, is nevertheless a person to whom this act applies by virtue of the provisions contained in this section. In Commissioner of Wealth Tax vs. R. Sridharan, the issue was whether a son born out of a wedding of a Hindu father and a Christian mother could be said to be a Hindu for the purposes of forming a HUF with the father for tax purposes. The second issue was, can a son of a Hindu father and a Christian mother married under the Special Marriage Act can be considered as a member of his father's joint family? The court held that legitimate children of a Hindu father and a Christian mother who are brought up as Hindus would be governed by Hindu law. Thus, son of a Hindu father and Christian mother married under the Special Marriage Act will be member of his father's joint family. In Perumal vs. Ponnuswamy, the issue was whether the marriage between a Hindu and a Christian was valid, whether the marriage fell within the prohibition of the Madras Hindu Bigamy Prevention and Divorce Act 6 of 1949, whether the plaintiff child could be held to be legitimate child. The court held that the marriage between Perumal and Annapalam was held to be valid. The court observed that for conversion to Hinduism, no specific expiatory or purificatory ceremonies was required. The prohibition laid down in the Madras Hindu Bigamy Prevention and Divorce Act 6 of 1949 was not applicable upon the parties, as the parties on and after the date of marriage resided in Kannimadam, which fell within the territory of Travancore, Cochin. The plaintiff child was held to be a legitimate one, as the father failed to prove or establish that there was no access with the spouse. Besides, the fact that the parties lived in the same village itself reflected that there was access of each other. The appeal was dismissed with cost. In Krishna Kumari Tamburan vs. Palace Administration Board, the first appellant, a Hindu now deceased, she married a Nambudiri and a male child was born in the wedlock. Later, during the lifetime of her husband and during the subsistence of the marriage, she entered into a relationship with a Muslim and begot 2 children, that is, appellants 2 and 3. The claim, which is adjudicated in the appeal, was one which was raised on behalf of appellants 2 and 3, who are the children of the first appellant born to a Muslim father. The claim was a share in the properties which belonged to family of the first appellant. The court held that the father was a Muslim and there was no assertion that the claimants were brought up as Hindus. Thanks to Slides Go.